in a state that requires licensure to provide ADLs, assistance, and so forth. I mean, there is, part of the design of that is to protect the insured. To make sure that there is quality control, and that there is screening of people who are going into people's homes and providing care to them. So it makes sense. It makes sense to require that. What they cannot do is they cannot require a provider to have a license greater than what is necessary to provide the ADL. In other words, a policy can't say that you need to have an RN or an LPN come in and do your ADLs. They can't write that into a policy because it's requiring a higher degree of licensure to perform functions that a lower skilled person can provide. So they've tried to do that. I mean, I had a case way back that involved, it was a really weirdly written policy, but it basically required the insured to have at least one skilled visit per week by an LPN or an RN or maybe some other, maybe respiratory therapy, whatever. One skilled visit per week in order for the unskilled part of the policy to cover the unskilled care. So this was a great case. Well, this particular individual did not require skilled care. So she did not receive skilled care once a week, but she was getting her unskilled care. The unskilled care was clearly covered under the policy, but only if you get that one skilled visit per week. So it's amazing how things happen. So in that particular case, I was representing a nurse registry that had provided the care under an assignment of benefits. So they were stuck with, I don't know how much it was, $15,000, $16,000, $17,000 in uncollected bills for the unskilled care they were providing to this woman. And so I filed a lawsuit, and I took it to the judge, and I said, this is impossible that this is legal. It's impossible that it's legal, that this device, this policy, would require someone to get something they don't need in order to receive something they clearly need and is clearly covered under the policy. It was absurd. I was stunned by it, really. It was unbelievable. So the trial judge did me a favor. He ruled against me. Did me a really big favor. And he actually said, I don't like this, it doesn't feel right, and I hope, and this was from that court reporter, this was all on record, I hope that the appellate court reverses me, and I invite the appellate court to do so. And so we appealed it, we briefed it up, and went down there and argued it to the appellate court, and waited for the decision, and the decision came in, and I said, remember, I was riding in my car, and the first, let me find it here. Is it here? This was the first line of it turned out to be a 15 or 16 page appellate court decision on really a collection case. It was unbelievable. It said, an ever diminishing few of us remember Alan King's story about a homeowner with a fire and theft policy who made a claim when his house burned down. He was met with the company's denial of coverage on the ground that he needed instead a fire or theft policy, and that, as written, the policy applied only if he were robbed while his house was on fire. And I went, I was like, yes. And they just crushed this company, really crushed the company. And so, it's the old adage, good cases make good law, and bad cases make bad law. Well, for me, this was a good case, and it made great law, but for the insurer, this was a really bad case, and it made really bad law for them.